This is the second report in the series dealing with contempt of court in criminal proceedings. In this report, we recommend the introduction of an electronic database recording the existence of certain reporting restrictions. This will make it easier for the media to discover whether a reporting restriction is in place, thereby promoting open justice, and it will also reduce the likelihood that a trial is prejudiced by information being published which should not have been. The Contempt of Court Act 1981 provides a power for a judge to order that a publication be postponed where it might prejudice a fair trial. Postponement is usually until the end of the trial or any linked trial. That power is found in Section 4, subsection 2 of the Contempt of Court Act 1981. To take an example, consider the case of a celebrity on trial for fraud. He has a previous conviction for violence from many years before. The trial judge has ruled that that previous conviction for violence will not be admissible at the trial for fraud. The jury will not hear of it. The judge in such a case might order that publication of the fact of that previous conviction for violence be postponed until after the conclusion of the fraud trial. That order would be made under Section 4, subsection 2. At present, the means by which that order is communicated to the media is by the order being printed and posted on the door of the court. That's clearly not an efficient or effective method of communicating to the media that there are reporting restrictions in the case. Unsurprisingly, the media find it difficult to discover whether there are reporting restrictions in place in any given case. And that poses problems for them because if they do publish material in breach of a Section 4, subsection 2 order, they are in contempt and liable to criminal penalties. The risk also causes the media to be unnecessarily cautious in some cases about what they report. In our consultation paper in 2012, we proposed a scheme that would bring this process into the modern digital world. Following the model already successfully operating in Scotland, we proposed that all Section 4, subsection 2 orders be made in electronic form, emailed to a central agency who would post them on a database which would then be available to the media representatives. The media would then be able to check with ease whether an order was in place in any given case. That provisional proposal in our consultation paper met with widespread approval. We conducted a pilot of a number of Crown Court centres to discover how frequently these orders are made and what the cost and resourcing might be of running such a database. We discovered that at a maximum there would be around 120 orders per month across England and Wales, and that the administrative cost of uploading these to a database would be minimal. We revised our proposal slightly in light of the consultation responses, and in this report we make two principal recommendations. First, we recommend an electronic database which is freely available via the internet. All Section 4, subsection 2 orders will be emailed to a central agency and posted onto that website. All that will be posted on the website is the fact of the order, the existence of the order. So, taking our example, it would simply report the case involving the celebrity had a reporting restriction, the name of the court in which that hearing was taking place, and the date of that restriction. It would not reveal on the publicly available database that the reporting restriction prevented the publication of information about the previous conviction for violence. Clearly, that would defeat the purpose of the reporting restriction in place. We also recommend a second database. That would provide the full details of the order which had been imposed under Section 4, subsection 2. That database would be restricted and it would only be available to individuals who had registered on payment of a fee. The individual who is registered and paid the fee is in the same position as if he had attended the court and heard the order being made by the judge live. These recommendations will allow the media to report more accurately and fairly on trials and avoid breaching Section 4.2 orders. In doing so, the media will be clear about what can be reported, and the recommendations will also ensure that prejudicial information is less likely to be released and to jeopardise a fair trial. We recognise that this model may, if it proves successful, as our pilot suggests it should, it could be rolled out to extend to other reporting restrictions in due course.